Society Criminal Practice Special Litigation Unit. And with me is Hannah Shapiro, who is an attorney from the Legal Aid Society Civil Practice Brooklyn Neighborhood Office, who specializes in advocacy on behalf of clients who are victims of domestic violence. We want to thank the conference for this opportunity to testify. You have our written testimony. I'm not going to read it. I'm just going to highlight some of the high points of that testimony. The Legal Aid Society strongly supports the adoption of the Domestic Violence Survivors Act. Passage of the bill would give the sentencing judge the discretion to consider the role that domestic violence plays in the commission of a crime and allow the judge to sentence survivors to alternative, less severe sentences of imprisonment, including determinate sentences, and in some cases, community-based alternative to incarceration programs. And second, it would allow the new sentencing structure to be applied retroactively to provide survivors who are currently in prison the opportunity to apply for resentencing. You have heard the overwhelming number, the percentages of women who are currently serving prison sentences who are survivors of domestic violence. In light of those figures, I find it really surprising the relatively low number of people who it's estimated that would actually benefit from the retroactive application of this bill. I think when we're talking about the resentencing of several hundred people currently in state prison, and that only the potential resentencing, it speaks to the fact that not only does this bill address an important issue, but it's not going to be terribly expensive if this thing is passed. I mean, we're talking about a few hundred resentencing applications, which, you know, in light of other things that have been done, Rockefeller drug law reform, for instance, where many, many more people are getting resentenced fairly. This represents a relatively insignificant cost to the criminal justice system. So I can't see in terms of cost objections that anybody really significantly could pose a significant objection. You've heard from earlier testimony the concern from the district attorneys expressed that this bill is overly broad. As I read it, I just do not understand that objection. If you look at the provisions of it, the defendant was, at the time of the offense, a victim of domestic violence subjected to substantial physical, sexual, psychological abuse inflicted by a member of the same family or household as the defendant. The abuse was a significant contributing factor to the defendant's participation in this crime, and the sentence under the law would be unduly harsh. That looks like an effort to shape a particularized, narrowly focused provision that will attack the problem to which it's intended to address. And so I just do not understand this objection that somehow this is overly broad, because in light of the narrowly tailored language of the bill itself, we think that simple fairness dictates that if we're going to change a standard for sentencing, that it should apply retroactively to those who are now serving the unfair sentences, lengthy prison sentences in our state prisons. It is also clear that the current domestic violence exception in the sentencing law just has not worked. It does not significantly lower sentences. In fact, the one person that we're aware of who has received that sentence actually got a longer sentence than was available under the determinate sentence. It does not allow alternative to incarceration sentences, and it's too limited that it only applies to homicide and assault against abusers and excludes any crimes that are committed as a result of an abuser's violence or threats of violence. As a result of all these shortcomings, the current provision is just, I can tell you, is not used by the defense community. It doesn't work for the intention that it was drafted. This bill is not only fair, but we think it will enhance public safety while saving scarce public resources. The addition of alternatives to incarceration programs, which can effectively address the needs of the accused, can only mean that public safety will be enhanced by passage of this bill. Thank you.
Good afternoon. I'm here on behalf of the Legal Aid Society's Civil Domestic Violence Project. Our project represents survivors in the areas of protection orders, custody and visitation, child and spousal support, property distribution, divorce, and domestic violence related immigration matters. I'd like to just speak a little bit today to the work that our organization has advocated strongly on behalf of our clients for economic justice. And although not one of the bills explicitly on the forum's agenda today, I would like to take this opportunity to voice the Legal Aid Society's strong support for the final maintenance guideline bills, which was passed 2 years ago in the Senate with the courageous and groundbreaking leadership of Senator Hassel-Thompson. The interim maintenance standards, which became effective in October of 2010, have been immensely helpful to our low-income domestic violence survivor clients. And with the Law Review Commission's report, which is expected soon, we want to renew our support for the final guidelines, with standards for both duration and amount. This remains one of the most important divorce reforms under consideration today. Our domestic violence and family law practice routinely represents low-income domestic violence survivors in divorce proceedings. We see firsthand every day how the lack of final guidelines continues to impoverish non-moneyed spouses and their children. The process of getting a divorce in New York has often and rightly been criticized as taking too long and costing too much in both dollars and emotional hardship. Currently, we are experiencing success with pendente relief under the interim guidelines. However, establishing a right to final maintenance remains so complicated it requires lengthy and expensive litigation. In divorces, maintenance remains the wild card in negotiations, impeding settlement, encouraging litigation, and most disturbing, forcing non-moneyed spouses to give up. Most prejudiced by the existing law are moderate and low-income spouses who cannot afford to litigate. This is particularly evident in the fact that over 75% of all divorces in New York State are uncontested divorces. Establishing final guidelines would help bring economic stability to many New York families upon divorce and reduce the legal costs and court time it now takes to litigate maintenance awards. Using formulas for amount and duration for final maintenance would be simple enough so that even litigants without access to lawyers could obtain final maintenance awards in the same way they are currently obtaining child support awards. Final guidelines are necessary to ensure consistency, predictability, and fairness. We are grateful for the opportunity to testify today. And I again want to thank Senator Hassel-Thompson and the senators and the entire Democratic Conference. Thank you.
Thank you.